Mr. Mitchell.
Mr. Chief Justice, and may it please the Court. The statutory definition of machine gun extends only to weapons that fire more than one shot automatically by a single function of the trigger. Mr. Cargill's non-mechanical bump stocks fall outside the statutory definition for two separate and independent reasons. First, a bump stock-equipped rifle can fire only one shot per function of the trigger because the trigger must reset after every shot and must function again before another shot can be fired. The trigger is the device that initiates the firing of the weapon, and the function of the trigger is what that triggering device must do to cause the weapon to fire. The phrase function of the trigger can refer only to the trigger's function. It has nothing to do with the shooter or what the shooter does to the trigger, because the shooter does not have a function. The statute is concerned only with what the trigger does and whether a single function of that trigger produces more than one shot. Second, a bump stock-equipped rifle does not and cannot fire more than one shot automatically by a single function of the trigger, because the shooter, in addition to causing the trigger to function, must also undertake additional manual actions to ensure a successful round of bump firing. Everything about the bump firing process is manual, and there is no automating device such as a spring or a motor in any of Mr. Cargill's non-mechanical bump stocks. The process depends entirely on human effort and exertion, as the shooter must continually and repeatedly thrust the forestock of the rifle forward with his non-shooting hand, while simultaneously maintaining backward pressure on the weapon with his shooting hand. None of these acts are automated, and the Solicitor General has yet to identify any component of Mr. Cargill's devices that automatically performs any task that is necessary for bump firing. The statute is unambiguous as applied to Mr. Cargill's non-mechanical bump stocks, and we ask the Court to affirm on that ground.
Behind the government's argument is a sense that this statute was initially enacted because of what some of the individuals did during Prohibition. Mm-hmm. And there was significant damage from machine guns, carnage, people dying, etc. And behind this is the notion that the bump stock does the exact same thing. So with that background, why shouldn't we look at a broader definition of function, one suggested by the government, as opposed to just the narrow function that you suggest?
The problem with the government's argument, Justice Thomas, is that the phrase single function of the trigger can only be construed grammatically to focus on the trigger's function and not on what the shooter does to the trigger. And that's so for many reasons. For one thing, there cannot be a subject of function because a shooter does not function a trigger. Only a trigger can have a function and not a shooter. Now, the Solicitor General is trying to replace the word function in the statute with the word pull. And if the statute had actually said a single pull of the trigger, that phrase would clearly refer to an act taken by the shooter, because only a shooter can pull the trigger. The trigger certainly can't pull itself.